In mid-September this year, 7 students who attend 4 different Detroit public schools filed this lawsuit, alleging that the schools were denying them of their right to literacy. Another way to say that is that they've been functionally excluded from public education. In this lawsuit, plaintiffs are basically asking for 3 things. One is they want evidence-based literacy instruction. 2 is they want to have a systemic approach both to this instruction and also to intervention. And 3, they want the physical conditions of the schools to be addressed so that those physical conditions are not themselves a barrier to literacy. It's interesting that the lawsuit is framed in pursuit of those 3 goals, which will necessarily involve additional funding. But the lawsuit is not framed as a funding lawsuit. So that's a significant shift in the approach. This lawsuit focuses on educational opportunity, and in that way, the plaintiffs have framed it as the natural heir to Brown versus Board of Education. So over the past 40 years, almost all states, 45 states actually, have had school finance litigation. And that is usually based on state constitutional language establishing a right to education. However, in Michigan, our state courts have been unwilling to hear those claims. One thing that's very significant about this lawsuit is that it has the potential to reopen federal courts for adequacy claims. About 20% of states, and Michigan is one of them, have a policy that says that any capital improvements are funded completely by the school districts. What that means is that if you are a property-rich school district, your ability to raise money to remodel your buildings, to do other sorts of significant capital improvements, frankly, just to maintain your buildings, your ability to do that is a lot greater than if you're a property-poor school district. And so districts like Detroit that are relatively property poor have really been hampered by this state-level policy. Part of what plaintiffs identify in their complaint are the physical conditions of the buildings, which sound terrible. So they talk about children wearing their winter coats in classrooms because it's so cold in the winter. They talk about students and teachers vomiting because it is so hot and becoming dehydrated in part because of that in the spring and in the early fall. They talk about teachers regularly cleaning up rodent feces before they start the day so that they can try and have a decent environment for their children to learn. Some other states, for example, say that the state must provide a minimally adequate education. Constitutional language in Michigan basically says that the state needs to create a free system of public schools. Now, we're not the only state to have language that's pretty similar to this. In fact, about a half dozen other states do. What's different about Michigan and those half dozen other states is that in Michigan, our Supreme Court has not interpreted that language as having any sort of quality guarantee. In the other states, they have all interpreted very similar language or the same language as having a guarantee of a certain level of quality for the education that is provided. So what we've ended up with in Michigan, at least under state law, is basically an access right, that children have a right to be physically present in some sort of school somewhere. And if that's the extent of the legal right that children have to education in this state, then is that being satisfied? Yes. The potential this lawsuit has is to really focus on a core aspect of a right to education. The right to literacy, because if children are not reading, if they're not reading at grade level, then that impacts their ability to acquire content all across the curriculum. And that just snowballs. And ultimately, if we have public schools so that we can create the next generation of citizens, then we are doing ourselves a disservice by continuing to let these schools educate the children in the way that they're currently doing. And so the question is going to be whether a court is willing to say, yes, this is a federal constitutional right. And there's a lot of variation in terms of what a court could say. One option, of course, would be to say that all children deserve an excellent education. And while I may agree with that from a personal moral perspective, I think it's tremendous legal progress from the perspective of the plaintiffs if a court says that children are entitled to a baseline minimally adequate education. And the Supreme Court has set up the opportunity for lower courts to also come to that conclusion. What this case is doing, among other things, is it's really testing out a new legal theory. And it's important for advocates all across the country to see how this goes. And so it's not a surprise to me that this case has already been covered by national media outlets, that a law professor from the University of Chicago wrote an op-ed in the New York Times about this piece. It is potentially that significant.